So let me just lay out for a moment the origins of this, so everybody who's viewing will understand your article here and how you pulled together the research. But in Canada, we have ankle monitor provisions for bail. If somebody's released on a violent offense, if they have breaches, they can be placed on an ankle monitor as part of the release plan. If somebody is convicted of an offense as part of the sentencing, they can be placed on an ankle monitor. And even if they are released from a facility while serving time, an ankle monitor can be imposed on them. And we have this also across Canada. It's available. It's typically used in much more serious violent cases. For example,
Like I was saying, has to be violence.
typically we have them in gun-related cases, shootings, things of that nature. There are some domestic cases. I mean, there are cases we know of where an individual's out on a domestic-related sexual assault in a high-conflict divorce, but had breached the bail so stupidly they wind up getting on an ankle monitor just because of the ridiculousness of what the allegation was. So there is some justification for it. But Quebec has an interesting approach, and this is where you pulled together research and did a very interesting article, which I'll have you introduce in one sec. But they have the anti-approach bracelet program, which has been implemented, if I'm correct, back in 2021. And this is to deal with typically, it's a tool to protect victims of conjugal violence or sexual abuse. It can be imposed on an offender during legal proceedings with the victim's consent. And specifically, they have it, as can be understood, to increase safety and feelings of safety among victims and address, of course, reoffenses and keep the offender away from the victim. So this is all within the context of somebody who's already been found guilty of an offense, but it can occur as well on a release order, as is noted in the Quebec actual section. And so what you did, which was great, was you did a piece, Quebec's Conjugal Violence Prevention System, a cock holds ring of digital enslavement of men. And tell us what you did and how long you were gathering the information to put this piece together.
When I read the article, which I think I referenced it in mine, I put it together from the construct of how is this so different than every other use of an ankle bracelet? And when I started thinking about it, and be honest with you, it made me mad when I started reading it. And I tried to pull together as much as I could about its use or its intended use and look at it from a positive standpoint. And I couldn't. I couldn't see a positive standpoint from it. I mean, I looked at, several Canadian laws. I mean, I looked at, the Criminal Code of Canada, Provincial Authority. I think it's 92 something. And okay, it fits in there. So I kind of get it. But then I looked at its intentional purpose, its use. And then I backed it into 99% of victims of false accusations are men. And right then it hit me like a ton of bricks was this isn't about protecting the victim. This is about victimizing men. And I went, okay, so I put it to the side like I typically do in my research, and I come back to it later. And I picked it up and I started looking at it again, and I went, I can't let it go. It just stuck to me. And I said, okay, let's make sure I'm not crazy. Let's start pulling in some research, start reading this. And I stumbled across a couple of aspects about the use of the application, the use of it. And it just a couple of things resonated with me. Like, one of the things I took a look at was there's no redress mechanism built into it. There's going to be obvious gender bias with it. I mean, let's face it. This is going to be on men. No women are going to wear this. So we have to say some truths here. We have to face the truth. And if that's the case, I now started taking a look at procedural issues out of Canada. And once again, I'm not an attorney. I just do a lot of reading. And I found, what was the case? It was a 1999 case. Um, some weird name. I'm
You and
sorry
Chuck.
for
Oh,
I can't pronounce it.
it's the seminal case
Iwunnachuk
on, yeah, you and
or
Chuck.
something like that.
Yeah, you and Chuck.
And it deals with consent and credibility. And I went, you're in standing violations of basic legal constructs already, Quebec. So why would you implement this specifically? It made no sense. There was no logic behind it. And that's what I kept sticking on. Then I went, okay, let's take it from the standpoint of there is logic behind it. What's the impact? And there's research out that says it'll have a long lasting impact. I mean, um, once you get over the psychological impacts of what's called commonly referred to as digital scarring. So now you've got an individual who, let's say they've wore it for a while, they've got through the system. Now they're going to be apprehensive about anything coming out of the legal system. Is they have that long-term trauma that's going to sit with them. And now you got the long-term trauma that's going to sit with them. How's that going to impact the rest of their life? How's it going to impact their job? How's that going to impact their relationship status? How's it going to impact their status with children? Now, let's just go a step further and let's just say, what if it was false? Now you're carrying that trauma with you the whole time because it's not something you can hide. You can't hide it. Everybody can see that thing, So now you got friends and business acquaintances and people you meet casually and kids.
Yeah, staring at your
Kids going to
ankle.
say, "Daddy, where's your bracelet?"
Did you draw a distinction between those who have it on a bail, on a judicial interim release while there's outstanding allegations, versus those who've been convicted after a trial?
I didn't look at it. I didn't get that deep into it because I wanted the article to do exactly what we're doing now. Have the conversation. Take a look and let's really dig down and have this discussion. Um, a lot of my research articles, I get well into the weeds with stuff and very detailed and they're long reads. But this one, I wanted to create a discussion. Let's talk about this because I don't see any positive aspect to it as far as men are concerned. And no one's talking about how it impacts men. I mean, 99% of false accusations are men. That's a reality. We have to have that discussion. And there's going to be people arguing it. That's fine. Go ahead and argue it. And there's going to be ladies that are going to say, I was falsely accused. I'm like, good, you're part of the 1%. Congratulations, you made the list. But you guys deal with this legally. Think about how many legal cases you've run into, and you discuss them. I watch your podcast where the men are fighting these false accusations, but now they're falsely accused and they're walking around with an ankle bracelet. I mean, why not just put a Christmas tree on the dude's head and make him walk around like that?
Yeah, look, I think
Might work.
no, it's a worthwhile discussion. I mean, I think by and large, I can't speak for Quebec, but in Ontario, and we have good familiarity in looking at the law across Canada. Generally when we look at electronic monitoring, it's when it's implemented for a release order, so bail, so somebody's charged with offenses and they're facing a trial, let's say in the domestic violence or intimate personal violence scenario or intimate partners, it's more the rarity, and justice of the peace and judges who are doing release orders are very careful about it. But it does occur. And then if you couple that with what you're saying, that you're on this release for a year, 2 years, you finally get to trial, you're found not guilty. This was a situation where you can say demonstrably it was a false allegation. The impact of that has been tremendous from a psychological, emotional standpoint, which has been documented through legitimate studies that you've cited in your paper, where you talked about this like digital scarring and others. But it also leads to significant bias within the family court and child custody proceedings, for one example.
Right. And you know how ankle monitors go. So let's just take it from the standpoint. Let's say you're a judge sitting the bench. Now the father walks in with an ankle bracelet. You're immediately going to assume bias because even though let's say you're a busy day, you got a full docket, and you didn't have time to read through all the details. Your client walks in wearing a bracelet and you're defending him. how are you going to approach that with the court? And especially now you have to defend against false accusation. I mean, I looked at things on this too. It's like presumption of innocence. That's under Canadian Charter Rights and Freedoms, Section 11. Let's take a look at privacy rights under surveillance, Section 8. Every time I turned around on this, it was not good. And so when it stuck with me, I'm like, I'm not as versed as Canadian law as I am U.S. law, but this does not look good at all in any construct I can put this under.
Yeah, so I think it's fair to talk about and draw the differentiation for this discussion for those people who are on electronic monitoring when they're out on a release order pending a trial versus those who've been convicted. And of course, we deal with convictions and we have appeals where it's pretty obvious it's an unsafe conviction. Right. So that does occur as well. But I think that the greatest impact of what you're talking about is where somebody hasn't gone through a criminal process, there has not been proof beyond a reasonable doubt, and you're on this release in this limbo period. And to be frank, I have to say, regardless of whether it's the ankle monitor or not, the pleading that the party who's on this ankle monitor is going to be faced with the other spouse listing out all of the allegations in the family court pleading, and then stating the terms of the release, including ankle monitoring. And there's no doubt that is a crushing blow to being able to get any movement to get access to the children of the marriage, subject to agreement by the other party. Otherwise, they are really stuck.
Exactly. I mean, I deal with fathers going through family court and child custody proceedings all the time. And yeah, the deck is stacked against us, but when we have our own government continuing to, build the wall higher, no matter how hard we try to climb the wall, it's just they're working against us. And to me, they're working against parental rights. And here in the United States, our Supreme Court has already ruled parental rights supersede that of property rights. But you have people with property rights get better proceedings through legal adjudication than parents do. And I always look at, and I'm a big advocate, and I sound like an echo chamber, but it's the fair and proper administration of law. That's it. And the fair part of that is so critical that if 99% of men are the victims of false accusations, sometimes landing men on death row through false accusations, then you have to understand the use of this can't be fair. It's impossible. It's impossible. Because here's the thing. Let's just say, because these family court proceedings evolve. You know this, Joseph. You know this, Michael. They evolve. Guess what happens? Men are going to start making false accusations. Well, now is the court going to make a mother wear that bracelet? According to fair and proper application of law, she should, but it won't happen. It's only there for men. We have to have a very hard discussion about the truth on this. The judges in the courts will not make women wear that. The only thing is for men. That makes it biased. That makes it gender specific. That makes it violate a ton of laws. Well, okay, the judges are going to argue. They're going to say, oh no, we'll make women wear that. Really? We're going to go through 65 years of collecting data to show you're wrong? Now you're going to assume the role of you have to now indemnify all the fathers for 65 years of your judicial bias, where it's not worth the risk, not worth the risk, not worth the risk at all.
Tell me about the United States, because as we started filming the podcast with you here, you were telling us about how electronic monitoring can be imposed in the family law context, but only on the federal standard, if I understand it, then would be the proof beyond a reasonable doubt. But that can happen in the U.S.?
Yes. So if you have a family court proceeding that, there's an issue of domestic violence, typically the courts will ask, okay, what evidence do we have? If we're going to monitor this individual, where they're at, where they live, where they go, make them charge it before they leave and go anywhere, then what do I have to carry me to that criminal level? Okay, there's recordings, there's eyewitness accounts, there's police reports, everything like that. Judges will at times say, you know what, you're a violent offender and you meet that violent offender category. Yeah, we need to know where you're at. Okay. Or if you're going through family court child custody and there's substantive evidence of, child molestation or pedophilia. Yeah. The courts are going to say, put this on. You can't move unless I know where you're at all times. But that's done through normal criminal and civil, normal conduct of court administration. So it's nothing new. But like I look at this as what if the courts here in the United States say, you know what? Yeah, we need to protect victims in domestic violence, and only women can be victims of domestic violence, even though all the research says 50-50. Okay, and we're going to implement this. Holy cow. Holy cow. And that's where, and I'm going to be really harsh on men. To the men in the judiciary and men in government, you're not above this law, baby. This law applies to you too. So if a woman makes a false accusation against anybody in Quebec, whether you're a police officer, whether you're an officer of the court, or whether you sit in government or administration, you're going to get slapped with this ankle bracelet. That's the double edge of the sword. And I don't think lawmakers are really thinking things through. I honestly believe they think they're above it. Well, as soon as you go down that road, you're going down a road you can't return from. And it never ends well.
Well, I just see it as definitely not politically expedient for anybody who's in government that make that argument for, equal application, because it's just not, it's not going to get them votes.
When are these bracelets imposed in the family law context in the States? Is there like a part of a restraining order, or when do they factor in?
Sometimes it's a restraining order, basically to go off of in family law matters. From what I have learned, is it's normally the police reports that start that process of wearing ankle bracelets. So the judges they'll get a police report in of a bad domestic violence dispute. Judge will bring the officers in the court. He'll read the police reports and he'll ask the officers what happened. And then there'll be a petition from either the victim, most definitely from the victim actually, to say, hey, she or he has a concern for their physical health and safety. There could be stalking mixed in with that too. Yeah, okay, yeah, now we're at an issue of I got to know where you're at, and if you get too close to the victim, yeah, we need to know that, and we need to know you violated this. So it's just like, from the way I understand it, it's just like the way things are done in Canada, so there shouldn't be any difference. But this is way different.
I think, again, what most of you, what you've focused on has been applicable to those who are on a release order and there's good demonstrative evidence that it's a false allegation at the end of the day. And based upon the studies that you cited, you were looking at the impact of this, as you said, digital scarring, erosion of identity and self-concept, fear of judgment and self-imposed isolation, entrapment mindset. All these are psychological and emotional impacts that occur to people after they may have gone through a very difficult time to essentially prove their innocence. And by the time all is said and done, they're so damaged emotionally and psychologically that they can't recover from it. And the ankle monitor has had just an additional element of scarring, of maybe vilification that has really pushed them to a point where they really feel quite marginalized, and then they don't recover from it.
That's very true. I mean, and your firm represents clients who are falsely accused. Think about the psychological trauma they go through and just fighting that. But now you add a blinking red light onto them and they got to walk around with that. That's additional trauma. It's one thing to go through this, false accusations, and I'm going to discuss that because there's a part of the male psyche that, yeah, you get mad that you were falsely accused because it's very unfair and you have that trauma, you have to deal with it. But you can internalize that and you can keep it private because it's very humiliating and it's very shameful. And then you fight through it and then you're on top. Okay, that's great. You've done it through the legal system. Like I did that. Okay. But now you're going to put an ankle bracelet on me every business meeting I go to, every time I pick up my kids, every time I walk around, I fill my truck up with gas. I can't imagine that. I really can't. And then to fight it successfully, and now you got to go back to the police officer and tell them to take it out. It's not like I can put an ad up on the front page of the local paper and go, "Hey, I was falsely accused. They're taking this off. Look at me. I'm vindicated." No, sir. It doesn't happen that
Well,
way.
that's the problem in general, that at the end of the day, when you do have a case where a client is either found factually innocent or the judgment is fairly clear that it is a false allegation, there is no mechanism.
No vindication
There's no
system.
way to redress that publicly. It just doesn't happen. And then, of course, we know that the charging or prosecution of false accusers is next to nothing.
Well, how about this? How about if the law was amended to say if a husband or a boyfriend was falsely accused, now the ex-wife or girlfriend has to wear that for the rest of her life?
Well, I think the way,
fair.
yeah, I think the way to deal with it is to have a judicial process, though. Like to have, if people, there has to be the willingness to hold anybody who does anything unlawful accountable. So if somebody makes a false allegation and then at the end of a trial, it's pretty damn obvious it's a false allegation, there automatically should be an investigation into that person and their conduct. And if it's established that there's reasonable grounds, they should be charged. And so if they go to trial and it's established that this was a false allegation, they're convicted of public mischief or whatever else you may have, then they face a harsh sentence. That's the way to deal with it. Because that would actually, in my opinion, have an impact on cutting back on false allegations. But that doesn't happen.
Okay, let me ask you this. As a professional in the legal industry in Canada, how many times have you helped a client successfully defend themselves against a false accusation in which now the other side receives criminal sentencing?
Zero.
Ditto.
Yeah.
Zero.
So that's where I'm at.
Yeah.
Zero. And I can tell you this year alone.
Everybody talks about the proper administration and fair conduct of law, except for when they look at the data, facts, and evidence and peer-reviewed research when it breaks it out by gender. And when you break it out by gender, the system is intentionally rigged against men. There's no way to look at that. You have to take a serious professional look at this and say, you know what? If a man's falsely accused and the false accuser is proven false accusations taking place, why doesn't she go to jail? Why doesn't the court go at her? Because now that would fix the system. And you're absolutely correct, Joseph. I'm not arguing that at all. But you just admitted it. It's never done.
No, it's not. I mean, this year alone, we've had easily, I can count on 10 cases where we're convinced it's a false accusation. 3 this fall that resulted in withdrawals where the Crown Attorney agreed that this was an unmeritorious prosecution where it looked like a false allegation. And of course, nothing will happen. And Michael had a very stark case where I got to tell you, it was fucking videotaped by the complainant. And when the video surfaced, it showed that the complainant lied and nothing happened. So and we've represented women. I mean, I've had female clients who the ex-husband quickly learns what to do, and same thing happens to her. It's not a sex assault, but it's a series of very serious charges, alienated from the children for quite a while, and so nothing happens. And that's the problem. We have to transcend this political fear of stifling women coming forward with allegations to just simply say, if you commit a crime, which includes a public mischief, which includes making a false allegation, you will be prosecuted for that. And then we have a level playing field where we may not have the same amount of false accusations, and the court system can then deal with legitimate, meritorious allegations. There's definitely violence against women. Women are victims of violence. It's like you said, it's not gendered, it's both sides, or it's all genders, let's put it that way. But we don't want to do that.
Yeah, and that's where you're hitting on a very, very key topic is it's to me, it's the preservation of the purity of law and the purity of the courts. Of anything that the purity should be maintained, and that's the purity of law. And how law gets adulterated is when it's unfairly administered to where you can now make a false accusation, walk out of court without any fear of repercussions. Okay, the courts will evolve. No, they haven't. We're 65 years into this. There's been no evolution. So what needs to change? I don't have a clear answer on that, to be honest with you.
I have to say that, there's always these pendulums swinging, and I've been delightfully surprised and with some very good Crown attorneys who've recognized this and some excellent judges in their judgments who've called out the falsity of evidence. The problem goes further. It's political to me. It's that we don't have laws on the books sufficiently with teeth in it to go after false accusers. And then there's that disincentive to do it. That's where it falls short.
Let me take it a step further for you. Okay. I would say that's not true. Let me explain that. And if a judge was sitting in court and it basically came out that someone falsely accused somebody, okay, as a judge, I now have the authority in my court to defer the false accuser over for prosecution. I can make a bench referment. Okay.
You
right
can
off
in
the
the
bench.
U.S.
Yeah, not here. Yeah.
Done. That's where I go back to the proper application and administration of law. It's not being properly applied and it's not being properly administered. And when it's not, you have people that have found a chink in the armor and they will exploit it to the fullest extent possible. And what that failure is the judiciary, the judges. It's a failure with the proper application and administration of law. Because when a false accuser is identified, you now have the victims have swapped. You now have a victim sitting in your court, judges, and you're not caring for the victimization. Now you've got violation of professional ethics from the bench. The victimizations are very important for judges to consider. Now you flip the switch. You've gone from this one's not a victim, that was a false accusation. Guess what? Boom, you now have an entirely different victim you're dealing with in your court, judges. And now you have chosen to walk away from that new victim because of politics. Now that means by judicial ethics, you should be censured and removed from the bench. And that's where judicial censorship's not stepping in.
Interesting.
You have to look at it from the victimization standpoint. If we continue to say, okay, the research is clear, everybody, age, gender violates at an equal rate. Okay. There's also research that says in non-physically reciprocal IPV relationships, men are 70%, more than 2 times the victim. Okay. Let's go back to 50-50. Everybody will agree to that. Okay, great. Let's go back. Now you got someone there to make a false accusation. It's proven false. Guess what, judge? You're now dealing with a victim looking at you, basically screaming in silence, I am a victim. And you intentionally get up from the bench, turn your back and walk away. That's immediate censorship of that judge. That judge needs to be, in my opinion, criminally prosecuted immediately. And we have laws in the states that say if that bailiff in the court doesn't write a signed written complaint on sheriff's department, police department letterhead and submit it to the United States Attorney's Office that a judge violated ethics or federal law, that bailiff can be charged with what? Felony obstruction. You see, it's a breakdown. It's a total collapse in the system in which we fail to realize who the victim is. We lose scope of that. When it flips, you got a totally different victim. That's a violation of judicial ethics.
So, Bill, are groups such as your own filing complaints against judges? Is anyone taking external steps?
Yeah, so we've got several complaints against judges out, and we're doing it intentionally. We're setting up, and we kind of talked about this in your last.
Yeah, I remember the last time you were on. Yeah.
So I often talk about when you proceed against the courts, you have to control your battle space. If you lose control of your battle space, you should withdraw, set up, and now encourage the enemy to enter your battle space where you control it. You lose your battle space, you're going to lose the case. Okay. So we have crafted up a set of strategies that essentially, in military terms, set up an L-shaped ambush in which these judges have walked straight into it full face. Now, have we filed criminal charges? We're not to that point yet, but we've set up a series of ambushes in which they knowingly are violating professional ethics, judicial ethics, and federal law. And based on our complaints and the written structure of the complaint, clearly stating violation of federal law and the Supreme Court and state Supreme Court cases that clearly articulate that in the complaint, they're ignoring it. What did I just do? One act in further conveyance. Duplicity. Multiple federal laws are just building. And pretty soon we'll have a strong enough case with multiple federal laws and violations. These judges will be facing what? U.S. v. Lanier. Federal prosecution. There's no way the court can walk away from it. Why? Because we've used the law to paint the judge into a corner they cannot escape. It's a process. It takes time. These judges are smart about this, except when you flank them, because they're used to frontal assaults. When you flank them and you take your time, one step at a time, they don't see it coming because they forget, oh, this complaint got filed way back then. Okay, we wait. Like I said, you make me mad, time is on my side. Time works against you. It's now in my favor. I take my time and they'll forget. And I got them.
All right, well, unfortunately, we're going to have to move on now. But Bill, we're going to have to bring you back because once you've got some movement in that regard, we'd like to hear about it.
Yeah, I have you, actually, you're top of my list. When we get movement on that, I promised you last time on the podcast, you're going to get the first call. So you'll still get the first call, Joseph.
Yeah, we want to know. So I thank you very much for authoring this and citing the studies. It's very good, and I'm glad you brought it to my attention so we could bring you back on, and it's really good seeing you, Bill.
It's good seeing you guys. I keep following you, and I'm so proud of you guys, and I'm just, every time I see like Michael won Attorney of the Year, I'm like, man, you guys are just bangers, man.
There you go, Michael.
There you go. Recognition.
You should.
Thank you.
Stand up,
Thank
Mike.
you.
I mean, that's hard work, dude.
Oh, we know.
You don't get that from being lazy. That's work.
It definitely is work. So listen, we wish you happy and healthy holidays. Have a great Christmas and a good New Year. And we'll stay in touch. We'll keep communicating.
Good deal. Merry Christmas to everybody, too.
Take care, Bill. Thank you so much.
Nice to see you again.
Be well. So, clearly he's speaking from a very American-centric
right, where things
perspective.
are
and
different.
I'm not familiar with exactly what's going on in some of their courts, but we're going to talk about some of that in another podcast.
Yes, we are. He'll be back.
But, I mean, this is why I say, I look, this whole issue about the anti-approach bracelet, I mean, it's nothing new here. We have it for violent offenses. That's why I like our system here. It's extremely measured about judicial interim release. It's very narrowly used if it isn't a domestic criminal case, and I think it and if it calls for it, and we know one case it called for it.
That's right.
I think it was an appropriate term on a release, and we know men commit violent acts, women do, but women wind up unfortunately getting some being at the victims of some very severe things. So I don't think this is inappropriate. Just it has to be handled a little bit
measured.
It has to be handled in a measured way. But I think he's really talking from what's in the U.S. going on, because I think our judges, I mean, from our trials in the last several years, there's been, by and large, I think, a very measured, balanced approach to analyzing evidence.
The judicial referment, that's an interesting concept down there. I didn't know they have that.
So much there that I don't even...
I know. The procedures at federal level and state level are... We'll get 𝐕 to come talk about that.
Yeah, it's... anyway, so it's interesting having them on, and if you found this interesting, please leave a comment. As we say with Pillow Talk, please like, share, and subscribe, and keep sending us those comments and emails, because that's how we get this information, and we can bring it to you. So,
and we'll give you the information for the article. If anyone wants the article, just let us know. We'll send it to you. Bill Corbitt's.
Happy holidays.
Yeah.
Have a good Christmas and a happy New Year and a happy Hanukkah and whatever else you may be celebrating. Good night.
Good night.